Well, now to our major story of the day. The House of Representatives today asked the acting president, Yemi Osinbajo, to swear in the two ministerial nominees, or do we call them ministerial designate, recently cleared by the Senate. The ministers designate from Kogi and Gombe states were confirmed by the Senate on the 3rd of May 2017. They are Mr. Stephen Ocheni from Kogi, nominated to replace the late Labour Minister James Ocholi, who died in a car crash, while Suleiman Hassan from Gombe, nominated to replace Amina Mohammed, a former Environment Minister now serving as the Deputy Secretary General at the United Nations. Well, let's get some legal perspectives into the matter now. On the call by the lawmakers, can the acting president swear in the minister designate? And if so, if he doesn't do that, what happens? Mr. Ikechukwu Ikeji joins us now to give perspectives onto this one. Many thanks for coming on the program.
Thank
so
you.
many issues to talk about, but on this one, should the acting president had sworn in these designates, these ministers, after they were being cleared by the Senate?
Absolutely. I think it's a given. It's not subject to debate or conjecture. The acting president is, to all intents and purposes, as empowered to the office of the president as the president himself, as the president is now presently absent. So it is a given that the acting president should swear in these two ministers. So the issue that the House of Representatives would have to wade in and ask, as it were, the acting president to swear in the two ministers. To me, I think it's overflogging the issue. It's trying to bring out issues where there are no issues.
But if, like the lawmakers are asking now, is the acting president bound by any law if he doesn't?
No. No, it is his duty. It's a responsibility.
It's just a moral or psychological duty.
No, it's a constitutional responsibility on his part to have ministers. But
can he is in acting capacity,
yes.
Does he have the power by law to do that?
Absolutely, that's what I'm saying. He has the power. Now, if you recollect, the section 146, I think, of the Constitution, of 147 of the Constitution, talks about appointment of ministers, and it says that as much as possible, ministers shall reflect the federal character principle of the federation. That means that there must be a minister per state of the federation. We should have at least 36 ministers. So, constitutionally speaking, there is an obligation, constitutional obligation on the part of the acting president to swear in these ministers and get them to start performing and representing, as it were, in quotes, their slots in the Executive Council of the Federation. As
it stands now, what does the law say because of this quota, the spread that the law has given for the appointments of these ministers in cabinet? What happens, or is there any part of the law which says if these people or if any state lacks seats in the cabinet, is there any provision that talks about that?
No, there's no penalty, as it were, penalty clause, as it were, in quotes. But since the Constitution has provided for it, I think it's only obligatory. If you like, I think it's beyond morals. I think it's a constitutional responsibility on the part of the acting president.
Is there also a timeline when the Senate screens nominees for them to...
No timeline.
So they can be screened and indefinitely they may
Absolutely. Just like there is no timeline that the acting president can act as acting president. In other words, the president can as well stay out of the country till May 29, 2019.
It's 66 days now.
Yes, and there's no timeline, there's no provision. In the same vein, too, there's also no timeline that the president can stay away before his seat may be declared vacant, or any kind of process is started to investigate whether he's permanently incapacitated or otherwise. That is a big lacuna in our
Is there anything in the Nigerian Constitution that the acting president cannot do in the acting capacity?
No, there is absolutely nothing.
So every power of the president
to all intents and purposes.
To declare war?
Yes, he is the president in fact and in law. So whatever the president can nominate do, everything.
Can it disband the cabinet?
Everything. Every power that the president has, the acting president has it. But unfortunately, Nigeria is a peculiar country. Today, we have a scenario of two presidents. We have one who is not available, who is outside receiving medical treatment, and perhaps whose kitchen cabinet, as it were, or trusted members of cabinet are still holding sway, and it may be kind of difficult for the acting president to have that kind of power, that kind of control, that kind of reining in that the president himself would have had on his appointees. Yes. And so that is where the problem lies. Not that it has anything to do with law. Legally speaking, constitutionally speaking, the president can do whatever the acting president can do, whatever the president can do, both in fact and in law.
Okay, as it stands now, I mean, I'm very sure you're aware about the lawsuit. Some lawyers, they say they're going to court to sue the National Assembly in asking the presidency to declare the health status of the president.
Absolutely.
Do they have a ground to do that?
Absolutely.
Yes, will not be seen as interlopers.
Well, you see, we have had problems with this issue of local standard. It's still evolving. At a point in time, the principle of local standard stood against any kind of litigation whatsoever where you are not an interested person or where your interest is not sufficiently represented. But along the line, after the case of Abraham Adesoya and the Federal Republic of Nigeria, a lot of lawyers started looking at it, and advocacy started, and people started going to court. It culminated in Gani Fahimi taking Babangida's government, then Akilu, to court, and in a criminal case, and it was decided that for criminal cases, that a person need not have local standard, a person need not have personal interest in the matter before the person can initiate proceedings. But beyond criminal cases, we still had the problem in civil cases. A lot of public interest litigations that we get engaged in were challenged by local standard, and they were thrown away by local standard. But recently, with the promulgation of the enactment of the Fundamental Rights Enforcement Procedure Rules 2009, local standard has been removed from human rights litigation.
Because the health of the president sometimes could be a personal reason.
Absolutely.
The presidency had said, look, it's the law, I mean, the doctor of the president and the president himself that can come out, or his family, as the case may be, to say
before you go, let's get this clear. There's an obligation presently on the Federal Executive Council to come out and catalyze, if you like, invoke that provision that says, that puts us on an inquiry, on a journey of inquiry into the health status of the president, without necessarily intending for that process to get to the president leaving his office. I think it's an obligation, a constitutional obligation on the part of the Federal Executive Council, and a lawyer can take advantage of this present situation and go to court and ask the court to exercise some judicial discretion in granting an order that the Federal Executive Council carries out its obligations under Section 144.
Okay. Before I allow you go, yes. Mr. Ikeji, I would like to give your thoughts on this one. Yesterday, take a look at the post of the wife of the president, Mrs. Aisha Abuari. She took to Facebook, and she's given in somewhat a parable, words in a coded or a crypted language about the health of the president and her husband. What do you make of what she said on Facebook?
Okay, I wouldn't want to get personal to what the First Lady said, but I can say that we all wish the president well. We want him to recover. But wanting the president to recover is not the same thing as allowing a vacuum to exist in perpetuity. So what the First Lady has said might as well fall in line with some of our intentions. We want a situation where the president is around and all executive actions, because executive powers of the federation lies on the table of the president, and enormous power that the president has. So it is imperative that we understand that the fact that the First Lady is making such a statement does not necessarily mean that she's antagonizing other people, but that she's merely stating what other people would like to see. That the president comes back and takes up his position.
We do all hope that the president comes back as soon as possible. Many thanks,
Thank you so much for having me.
Ikeji, always a pleasure talking to you.
I'm most obliged.